Okay, well, this is the second episode of our family law podcast, of us talking about things that are affecting family law. The topic that we're going to talk about today is COVID-19, which is a strand of coronavirus. And I think that is the end of the science that we're going to be discussing. None of us claim to be in any way expert on the politics of things or the science of things, and I think we're deliberately going to keep that to an absolute minimum. What we're going to talk about is the effect that it has on family law. I live in a part of the world where changes have been made to everyday life in the last few days, where restaurants have been closed, bars are being closed, gyms, the mall, cinemas. Lots of countries aren't able to have flights into the UAE. And so we're a little bit ahead, I think, of England in terms of the restrictive measures that are being put in place. We're not quite at Italy levels where we are. But I think it's probably fair to say that restrictive measures are likely to happen on the horizon. And when they do, life is going to change a lot for a lot of people, particularly in the world of family law. And the way that I see it is either it will be because of measures that the government impose, which may seek to restrict movement or access to public spaces. I think that's one way. I think the other way is just from a moral responsibility kind of view, where, you know, if people that you come into contact might have elderly relatives or children or suffer from asthma or be in a vulnerable category, and because of that, public spaces then become a lot less safe than they were a month ago or 2 months ago. And we, I think, will, as a society, look at public spaces perhaps a bit differently. And then there's loads of interesting questions, which we're going to talk about in due course, about, you know, as a practitioner, as a professional, as a social worker or a CAFCAS officer or a client or a party to proceedings, you know, are you obligated to go to an unsafe public space? And I think that's a really difficult question that it doesn't seem there's a clear answer to at the moment. But the way we're going to do this is we're going to do it in two parts. So the first part is going to be talking about practical things, about the effect on the courts, on the professions of the bar and solicitors, about access to justice, and about those kind of things. The second part is going to be looking at some family law issues, children and finances, and how coronavirus might become relevant as an issue in those areas. And so with that in mind, let's get ahead with part one. So in terms of part one, Ben, I know that you were in court literally today.
Yeah.
How was your experience of court today? Was it any different to what you would experience otherwise, or not?
It was different. It felt very strange, actually. I mean, I don't know about you, but to my mind, the world feels very different today. This is Monday, the 16th of March, than it did, I think, even last Wednesday or last Thursday. There's been an awful lot in the news. I think this last weekend has changed a lot of people's attitudes to the entire issue. And I went to court today, and I mean, the most obvious, immediately noticeable thing was that the security guards all had plastic disposable gloves on, all of them. And they were all being quite careful about dealing with the public as they came in. The waiting rooms were odd in that people were making a very obvious point to sit quite far apart from each other if they could. You catch snapshots, don't you, of conversations in courts. Always very interesting, the snapshots you hear in courts when you're trying not to listen in. But everyone was talking about COVID-19 and coronavirus. And that was literally the only discussion that was taking place. And so I found myself down in a court building today, and lo and behold, there was an immediate effect of the coronavirus because the respondent in my case didn't attend court because they emailed in on Friday to say they were self-isolating. And so that was an immediate difficulty that presented itself. That I was in court one-sided with a judge, with no respondent, because they had taken the view they needed to self-isolate at home. It was an odd atmosphere, absolutely. Yeah.
Well,
and I've heard stories from colleagues.
Space, right?
Yeah, and I've heard
courts are public spaces.
Courts are public space. Courts are public spaces, and the the difficulty is, and I think the point we were going to come on to make, is that the difference with a public space such as a park or a public space such as a swimming pool is you voluntarily attend a park and you voluntarily attend a swimming pool. You don't necessarily voluntarily attend a court building. Sometimes you're attending a court building under compulsion. Sometimes you're attending a court building because you're a professional and you're doing a job there. And so I went along to this court today and popped into the gents. Incredibly, to my mind, there was no soap in the soap dispenser. I worry to what extent the court service is geared up for this sort of an issue. I'm sure they say they would be, but my immediate experience today was in the height of the concern about coronavirus. I went to a court where they had no soap available. I mean, I found that extraordinary personally, but I hadn't.
Well,
I was there because I had a job to do.
The court service has been underfunded for a long time, as we know.
Yeah.
And we know, I suspect between all of us, we've been to hundreds and hundreds of court buildings, and I'm yet to go to one that has facilities that I would describe as particularly nice. I think that there are some really despicable examples of hygiene in some of the court buildings. Something like this really shines a light on it, doesn't it? Because when we're being asked to provide additional hygiene, should we say, in our daily lives, when you don't have the facilities provided to you in your place of work, or a place then, as you say, that you've been compelled to go to, you really do wonder the extent to which people are being kept safe in that environment. And the court service has a duty of care, I believe, over the people that it invites and also compels to come to their buildings. And if they're unable to keep those people safe, then I suspect that they're failing in that duty of care. I mean, Helen, one of the things that I have been debating with people over the last few days is a solution to compelling people to physically go to court buildings, and that is in remote hearings. And I posited that it would be possible, mainly I think in financial remedy cases at this stage, and maybe some children cases, but maybe not all, to very quickly implement a system which allows parties who are represented in particular to give judges the option of attending remotely. And that would look like there being a secure video link that the parties would organise, and the judge can be anywhere, the parties can be anywhere, the lawyers can be anywhere. I know that both of your chambers are particularly good when it comes to facilitating remote access. I have taken advantage of that myself with different members of your chambers and yourselves, obviously. And so I think that in the private sphere, we're very adept at dealing remotely with attending hearings. Private FDRs take place remotely all the time. I have a private FDR anecdote, what I'll tell you later if you're interested. And so what do you think, Helen? Do you think that remote hearings are a viable thing going forward? Or do you think that opposition to change and technophobes are going to be the barrier to it progressing well?
I think remote hearings are viable. I think that they are viable with the technology that people generally have. So not only solicitors and the court service itself at the moment, because as long as we all have a laptop or a smartphone, we can attend a remote hearing. That can work. Yep. It can work either with video or it can work just with audio. And courts do, and quite often, in particular in the civil courts, they use telephone hearings frequently. There's no video, excuse me, but there is obviously audio, and judge attends from wherever the judge is and the parties attend from wherever they are. But usually you would have the barrister, the solicitor and the lay party together in one room so that you're able to confer and give instructions and so on. Although I have done telephone hearings, again, remote from my own lay client as well, and that hasn't been a problem because you can communicate before and after and by email whilst you're doing it. But so I think that's viable. It can happen. It could happen. I've seen your draft proposed amended direction, and I think that's perfectly viable. I think the problem comes when there are.
I think.
No, but
it's presumptuous to start drafting practice instructions, but yeah.
We should present the courts with the argument that we want them to agree with. So I think that's a good way of doing it. But I think the problem arises frequently where you have more than two parties in a case, trying to have several parties all trying to give their points of view and keep that in control when you can't see someone face to face, or when you're trying to manage an overloaded computer link is a problem. The court service computers are absolutely, again, really old-fashioned. The video links don't work properly normally, let alone in times of crisis, I'm sure. I understand from Ben that he discovered that the court service still run on Windows XP, which is fine if it's a closed circuit and there's no issues with that. But obviously we're not closed anymore because we do use the internet for these sort of things, and for the remote links that the courts use. And then I think the other problem arises with people trying to actually give instructions or take instructions from their clients, particularly in those cases where clients are vulnerable. And you see this most frequently in court of protection proceedings or in care proceedings, where people need to be able to give good quality instructions, perhaps via an intermediary, to their legal representatives. And that's very difficult when it's not face-to-face. And so those sort of cases, I think remote working is going to be very difficult. And of course, it's a question then of how do you keep these people safe? And how do you make sure emergency hearings take place when they need to take place, rather than relying on remote video links, people having phones available to them, people having this technology available to them, and the funds to do so as well in some of those sort of cases.
I think it's worth bearing in mind that in some countries close to England, so Ireland, and perhaps close to England in the ways in which they practice law, Australia, have actually shut down their courts for the time being, and I think until April. And the direction that I read from Ireland was that all cases in family law were adjourned, save for emergency cases, which would be decided by a judge, who would be a gatekeeper. They would then work out how those hearings would take place, but the vast majority of them were expected just to resume after April. I personally believe, and this is why I was so active in trying to find solutions to the current problem, that we owe our clients a duty to try and help them find solutions and outcomes to their family law problems, because I think those there are issues which require resolution, and if you let those go longer without resolution, then all kinds of issues could arise. And if people, let's face it, and we're going to come to talk about this in part 2, but coronavirus and COVID-19 are going to cause problems in people's families with access to children, or in the ability to afford maintenance, or the ability to pay lump sums, or the ability to do anything, or to negotiate. We'll talk about all of that in part 2. But if you deny people access to justice during a time when these problems are going to be arising, I think that causes a huge issue for vulnerable people, and not just vulnerable people, but just maybe everybody. And I think it causes chaos. And I think the people who lose out in that situation are, as I say, the most vulnerable, but also, everybody who needs an outcome in a family law case. And so I have been discussing this now for perhaps a week with people, and I've been interested to hear what people have been saying in terms of the barriers to remote hearings. Helen, you've touched on some of them, which are, it's much harder with litigants in person, much harder with vulnerable people, much harder to take instructions remotely, and I accept all of that. But of course, we bear in mind that if it's going to be a matter of the government have just restricted freedom of movement and it's not possible to do it, then what else are you going to do? That's got to be the best next thing, hasn't it? But Ben, the thing I'm interested in, and from your perspective as somebody who's done a great deal of cross-examination in his career, one of the main arguments that I've had put to me is that cross-examining in particular over a remote hearing is really hard. Because trying to focus on people's body language, you just don't get the same cues. It's much harder to see what the judge is doing, can't follow the judge's pen in the same way, all of those things. So What do you think, Ben, about the prospect of cross-examining remotely during a remote hearing?
Well, so when you're in a courtroom, cross-examining a witness, you have the bundle, they have the bundle, we're looking at the pages together. It's much easier to cross-examine a witness when they are absolutely there, within eyesight of you. You can go through the documents together with them, ask them questions about it. It is much, much harder when there is that distancing created by a video screen. It just becomes one further layer removed. And I've done it a number of times, and I have to say I never ever relish the prospect of cross-examining someone over video link. And the other problem as well is, of course, you're never entirely certain who's in the room with them, because you know, of course, if they're in the courtroom, that they're on their own in the witness box. There's always the fear that just out of camera shot there might be someone else there, or they may have someone that they can confer with. It's much harder. It's much harder. It's possible, but I can't say I enjoy doing it.
May I play devil's advocate for a moment with you there, Ben?
Of course.
Because of course bundles are going electronic,
They
as we all know. And if Mr. Justice Mostyn had his way, they would all be electronic all of the time. And so you're probably going to have to get used to dealing with electronic bundles as a matter of course, although I take your point, they will be on a screen rather than a couple of meters away from you. But just to raise that with you, of course. And then the other one is that when you're thinking about, what was I going to say? What was the things you said? So you said if somebody's in the room, and what was the other one?
They're out of camera shot. You may have someone else in the room with them.
But you could always, so if somebody's out, if the problem is that you say, I always want to be able to watch somebody, that's just a matter of making sure that the facilities provide that, isn't it? Right at the start. And you can say, you know, because here's the thing, right? At the start of a private FDR, we spend 5 minutes when we're doing it remotely fiddling around with camera angles and making sure that, you know, people can always see the judge, the judge can always see the parties. You know, that's a really common thing in private FDRs, where you make sure that all of that aspect of things is taken care of. So why would it be any different in a cross-examination situation?
Well, if everyone's confined to their homes, you might find that you're cross-examining someone from their front room rather than in a dedicated video conferencing suite.
Yeah, and that might lend to them taking it less seriously, or, you know, not maybe justice seeming to be done in the same way. But ultimately, I have a theory with remote hearings. I think the problem is that people haven't really done many of them. I think that's the problem. And I think people, because they haven't really done many of them, and somebody told me off on Twitter, by the way, by saying, oh, this is outrageous. I can't believe you're saying that it's just a matter of fear and, you know, opposition to change. It's not that, you know, they're really serious issues. And I respect that. There are lots of very serious issues that need to be ironed out. But I suspect the reason why they haven't been ironed out, or that people are worried about them, is just they haven't done many of them. I mean, Ben, do you not think that you'd feel a lot better about cross-examining somebody if you'd done it 50 times remotely and you'd worked out how it feels and all the things that you could do that would make you feel more comfortable and all the things you could do to make yourself more effective?
It goes without saying, but I still don't believe that cross-examining will ever be as effective over video link than it would be when you're in the room with the individual and the judge, where the judge can see you, where the judge can see the witness all at the same time, where we're not just squares on a screen. I think that's a very important difference, a very important distinction. There are certain types of hearings that lend themselves very well to remote hearings, and there are certain types of hearings that do not lend themselves very well to remote hearings. And in the world, and in the sort of work I do, which is almost exclusively financial divorce work, financial remedy work, actually I think that those cases do lend themselves quite well to remote hearings.
I agree with
so
that.
the sorts of hearings that I think would work very well would be an FDR, for example, a financial dispute resolution, a negotiation hearing in a divorce. And the view I've been coming to quite quickly is, whilst I would like to think that the court service will get on top of this quickly, and if we are in a situation where sooner rather than later more and more people are confined to their homes and are not able or not willing to travel to court for all the reasons we've discussed, whilst I would like to think that the court service will step up to that task and deal with it by way of video hearings, I just don't think that the court service is funded well enough to allow that to happen properly. And in my view, what is very likely to happen, I think, is a significant shift away from the court arena to the private arena. And what I would like, or I hope there would be, because I think it would be very successful actually, is I think there should be an increased number of private FDRs. If cases don't settle, ultimately arbitrations, private trials. And that is where I think this is going to be most successful. I think that what we'll find is that parties will settle their cases over video link, separately from remote locations, with a tribunal who's able to give them their full attention for as long as they need it, and isn't in a pressed busy list like you'd find at court, and having to deal with video hearings at the same time. That's where I think it's going to be most effective, certainly in my view.
Well, can I add another couple of hearings which lend themselves really well to remote hearings are first appointments, which yes, arguably could all be remote. There's no reason for a first appointment to require personal attendance, even right now, I would have thought. And MPS hearings, because the MPS hearings can be conducted, I would have thought, without in the main course without oral evidence, as we know. Yes. They're normally just on the papers. Normally there's an outcome that the judge can, indicate pretty quickly what they're thinking. I think there are lots of financial remedy hearings that would work really well, but I guess the problem really comes when we think of family law as a whole. And look, I'm not a public law child practitioner. I don't know a lot about public law child hearings, so I'm not in any way claiming any knowledge or about the appropriateness of it for that. I just worry that if justice is going to be denied to people, that if you're not going to offer a solution and you're just going to say, well, see you in April, bar the emergencies, I just think that's a lot messier. But Helen, when you think about remote hearings, is there anything else that you think would be problematic in terms of them being an effective tool going forward?
I think as the points that both you and Ben have made about the first stages of financial remedy hearings, I agree entirely with you both that they could be done remotely without a problem. I think trials are different, and I agree with Ben when he makes the point about the immediacy being lost, although not in the same way that it is in, for example, criminal cases in front of a jury, where the research, as I understand, has recently shown that actually jurors tend to treat that evidence as being something as though they were watching it on TV and don't apply the same degree of gravity to it as necessarily it would happen if it were happening in front of them in the room. And so, but whether or not that would apply then to judges considering that evidence, which is what, of course, we have in the family courts rather than juries, whether they would then feel that disconnection is not something that's actually been researched or assessed, I assume. So I think, but that is a risk. I think trials, really, you need to have them face to face, but the problem is, can we wait? And how long do we have to wait before we're going to have that trial, especially if it's coming up about now? And in circumstances where, for example, a colleague of mine today was meant to start a 3-day fact-finding, the judge was self-isolating, and consequently it was adjourned. Self-isolating as of this morning. Consequently, it was adjourned. And then the privately paying parties have paid, ready to start a 3-day fact-finding. And they don't have money to throw away in relation to that. And what do? Is the court service in a position to pay the ex gratia payment that their solicitors might then be asking for? And it also causes, there's a prospect of bad blood arising between parties and the solicitors. You brought these allegations and you're not getting a chance now to pursue them, or you brought the allegations and I'm not getting an opportunity to defend them. We've got to wait in this limbo. I think that's really tough on the individuals concerned. Again, in situations with care cases, I used to do a lot of care work, so I do know that obviously it's extremely pressured, extremely fraught. People are very concerned with what is going to happen with the children in the centre of proceedings, and you need to have that immediacy. You need to have the decisions made. So for interim care orders and for emergency protection orders, somebody needs to make a decision, and needs to make a decision quickly on what should happen with those children. if you've got to get everybody together at the same place at the same time in front of a judge to make that decision, or in front of magistrates, a bench of 3 magistrates and a clerk, that's going to be a real effort that the courts are going to struggle with, I would have thought, unless you can all pitch up at one place.
But Helen, isn't there, I mean, look, again, I'm now straying into an area I don't know a lot about, so I'm just hypothesizing, but of course, isn't there a part of that story before even the court proceedings where are you going to require social workers to go to people's homes to investigate these issues when, you know, they've got no idea what they're going into with regards to coronavirus? And of course, you know, are people going to start using coronavirus as a means of escaping being assessed? Are they going to start saying, oh, well, we're isolating, so got to stay away from us? You know, our local authorities now going to be challenged to peer behind that assertion and try and test whether it's true or not. Because here's the problem. Again, this is said without any political leaning, but my understanding in England is that people just aren't being tested for coronavirus or COVID-19. No. So I can say, I've got a cough, I'm self-isolating, see you in 14 days, and that's the end of it. You'll see me in 14 days.
Yeah.
But what happens if that's a family that a local authority are investigating? What happens, you know, are the local authorities going to go, oh no, well, we just have to see them in 14 days then? Well, what are we going to do about it? And what happens to the child during that 14 days? I mean, and that then brings me on to, you know, a real worry that I have generally. And my worry is for the bar, because, and actually for judges and for court staff in particular, because for barristers, their job depends on going to places, largely, in large part. I remember with fondness traveling around the country on public transport every day of the week and going to lots of different courts all over the place. And now I get to just sit at a desk. Well, actually, I don't get to sit at my desk anymore. I get to sit in my spare bedroom pretending it's my office because we're under house isolation, whatever you want to call it, not because of any coronavirus, but just because that's what we're doing, work from home. So I worry about barristers and what it's going to look like for them. I worry for judges who, you know, themselves, I mean, I don't want to be unfair to judges, but maybe are in a higher age bracket to maybe other professions. I worry about court staff who are being asked to go to a place every day where literally hundreds of people might be going through who could have come from anywhere, could have just come from Italy or China for all they knew, or somewhere else. You know, what is the impact professionally on all these people going forward?
Well, it's very difficult to tell at the moment, but I can tell you there is a huge fear at the bar generally about what might happen. I mean, there's talk, of course, about potentially having to isolate for up to 4 months at a time. That's, if you read certain news articles, if you listen to certain podcasts, that's the suggestion, 4 months at a time. And you've got to remember that the bar's a self-employed profession. If you don't go out to work, you don't earn. And there are people who, you know, there are people with families. Many barristers have got children. The vast majority of them have got mortgages, got bills to pay like anybody else. And if, like any self-employed person, if you simply cannot work, there'll be no income coming in. I know there's been a discussion going on Twitter about what's going to happen with so-called returns. So generally what will happen is if a barrister can't do a case for whatever reason, it's returned. They return the case to chambers and the clerks will give it to somebody else. Might be somebody more senior or somebody more junior. And that individual, that other barrister, will go to court, will do the case, and then because they've done the work, not unfairly, they'll receive the fee. What will happen in this scenario? Should we treat this scenario differently? I know there have been a lot of discussions about this, but if people are going to be off effectively, long-term isolated or long-term sick, and are returning cases, is this a time when perhaps the bar should reassess generally its approach to these things? Should there be a general policy introduced, and it can only be an informal policy, but should there be a policy introduced where the returns are split, the fee returns are split, so the original barrister still receives something, and the barrister who's done the work also receives a share of the fee for having done the work? But the difficulty is, and the bar is a very strange and anachronistic profession where we're all self-employed, but at the same time we're members of chambers who to a very large extent really act like extended families. And we have to walk this odd line between being self-employed and being in charge of your own cases, your own workload, your own life, but at the same time looking out for those that you work with. And actually, I think to a very large extent, barristers, we've got to look out for each other and care for each other. And if this is going to be a long-term problem and people are going to be off on a long-term basis, then the bar is going to have to think long and hard about how to ensure that nobody's allowed to fall in this scenario. And I think that's a very difficult question.
I think it's important to say at this point that obviously, there are lots of professions that are going to be impacted. There are lots of self-employed people who are going to be in far worse positions. There are people who are going to be really devastated, businesses, individuals who are going to be struggling. The reason we're talking about barristers, of course, is because this is a family law podcast and we are, in fact, all barristers. So we're not just saying that barristers are going to be the worst hit. That's certainly not what we're saying at all. We're just talking about it from a barrister perspective, because I think a lot of people misunderstand how barristers work, actually. And I think that they assume that they've all got it easy and it's just, fat cat lawyers, which is what, if you remember with the legal aid reforms about 10 years ago, was the charge that was laid at barristers. And of course, if the phrase fat cat could be applied to anybody, it probably wouldn't be family lawyers, would it? In terms of the legal profession. But because there are so many really hard-working family lawyers who do a great deal pro bono and do a great deal for their clients. And somebody once said to me with family law that as soon as you stop caring, then just quit, because it's that kind of area of law. There's no greater reward from doing it than helping out your clients. And that's why I feel so passionately about this situation, because I think the way to help the professions maybe is to make sure that we're able to help our clients, because that's what we do really well every day. That's what we fight for. And, for some of us, that's what we were born to do, to help people and to fight hard. And if we have that facility of court taken away from us, then finding an alternative to do that, I think is a really positive thing, and not something that we should be overly critical of. I think it should be solution focused, not critique focused. But Helen, the other worry that I have, and we said about judges before, we're going to face a huge amount of disruption, I imagine. Both of you have already started experiencing it through chambers and through yourselves, where judges can't sit. Maybe a judge has had a case for 2 years and now they can't do it. They can't do the final hearing when it comes to the crunch. Maybe a barrister can't do it, having done it for 2 years, and they can't do it when it comes to the crunch, and clients are going to feel let down. There's an element of that happens anyway to a point. That's just going to happen more and more. But when you think about judges, do you feel that judges are entitled to say, not self-isolate, because of course, that's just the sensible moral thing to do, to self-isolate. But do you think if you're a judge who maybe is worried about COVID-19 and coronavirus, are you entitled to say, sorry, I'm not going to have people come in front of me that I don't know where they've come from, because if I contract it, I don't want my family to get it. I myself might have respiratory issues. I might be somebody in my 60s. I think judges sometimes get forgotten about in these things because they don't necessarily have a professional body that advocates for them in the same way that the bar does and solicitors do. Do you think that judges are entitled to say that, or do you think that they have a greater responsibility just to get on with it and help people out?
I think that they need to have a steer from the court service, from the Ministry of Justice. I think they need to have that backup behind them to be able to say to everybody, look, I'm not having people coming in front of me. I'm not going to have my staff here. My staff have to work from home, or they've got to work in sterile pods or some such. And so if it's just me in a courtroom, I don't want anybody else in front of me. So that's when you would be, again, looking at remote working. And I do think people have an obligation to protect themselves first and foremost. But actually, what the government needs to be doing, as they have done throughout Europe and further afield, is provide some more direction on this and say, actually, perhaps, when does the time come that we are going to have a hiatus in the courts running? Ben, I know you've done some research into what happened during the Spanish flu outbreak. But it appears that the courts did continue to run then, in about 100 years ago, in fact, wasn't it?
So just out of pure interest, I went to the Times website and I didn't type in coronavirus, but I typed in flu, influenza or epidemic. And I found this little article. It's not actually about England, it's about Paris, from the Paris correspondent. The epidemic of influenza. It's not the Spanish flu epidemic at all, actually. January the 1st, 1890, even earlier. So I think the point from this, that these issues are horrendous, but they're not necessarily new. According to the Times Paris correspondent, 20% of postmen and 30% of cabmen are suffering. In the law courts, many cases have to be postponed because the barristers are unwell. So there you go. It's been reported on before. Yeah, I mean, illnesses and epidemics are always going to have serious effects on national infrastructure, the courts included. In terms of that issue about what should be the position vis-a-vis judges, well, I think judges are really judges to a very large extent are no better or worse position than any other employee. They have to be provided with a safe working environment, and that safe working environment needs to be in such a way that they can ensure that they are not going to come into dangerous contact, as it were, with people who could infect them. But I have to say, at the same time, we talk about judges and we talk about barristers and these sorts of concerns and court staff. But I've got a friend who's an A&E consultant. So he's on the front line, and every day he's seeing people who present with symptoms of coronavirus. And you know, I mean, I'm not trying to draw a comparison between a judge and an A&E consultant, or a judge and a nurse, or a judge or any other healthcare professional who's on the front line. But there are lots and lots of people in the country at the moment who are having to undertake their jobs in unusual circumstances. And ultimately, the courts are a vital component of the general running of the nation. And I don't think that the court should be allowed to fall into such a position where they're just not functioning anymore. And if that means, I'm afraid, that judges have to work, well, judges have to work. So do we all. But we have to work in an environment that's as safe as possible. Absolutely.
Let me just jump in on behalf of judges, because I feel that I can, if ever a judge was in the unlikely event to listen to this, I can imagine them jumping up and down saying, well, one of the differences between me and an A&E consultant is I haven't had training in how to deal with infectious diseases. I'm not provided with equipment to protect me, and I don't have a whole team of staff to help disinfect the environment in which I work in, which are things I imagine are all available to an A&E consultant. Just putting it out there as on behalf of journalists. So
I think you'd be surprised.
Helen, okay, yeah, I probably would, yeah. But Helen, I have a solution to all of this that could solve, I think, a lot of problems. And I want you to help me out. I want you to help me out and see if this is a good thing or a bad thing. So as I mentioned before, one of the things that the government then did, which was completely crazy, in my opinion, was massively slash legal aid. And they caused terrific problems to the whole legal profession, the operation of the courts, access to justice, all kinds of things. And suddenly people went from maybe being able to access legal aid to definitely not being able to access it unless in situations of domestic violence, or if it was automatically available in child abduction or care proceedings, which massively reduced the amount of people who could access it. What about the government revisit that position and they make legal aid, instead of just investing in something randomly, why not invest in legal aid? And why not create a legal aid fund, maybe even just for this period of time, that will help vulnerable people, help litigants in person access lawyers who in their professional capacity can facilitate remote hearings. And look, I'm not obsessed by remote hearings. I don't just keep going on about why I think remote hearings should work. So it's a drum that I'm happy to beat, but I don't want to just keep beating it, ad infinitum. But do you think that that could be one way that the government could solve the problems that have been raised with regards to people accessing remote hearings?
I don't think it's going to take away from problems with delay in the court system itself. I think it would help with people being able to access early legal advice, and being able to set up private decision-making situations, such as arbitration, both for children and for money cases. And arbitration for children is now going to include, where it hadn't before, internal and temporary, I think, and permanent relocation outside of the jurisdiction. Right. So previously it was restricted to being just non-contentious without safeguarding issues in the UK. That was the jurisdiction of children arbitration, but also money arbitration I think is viable, and early neutral evaluation or private FDR hearings for money cases. That would be I think taken up with much more frequency if legal aid were available to people to get that advice in the first place, and that legal aid franchise solicitors were willing to do that rather than relying on the court system to provide that service now, in times where it's going to be really struggling, more so than usual, because it's got to now apply its resources to sorting out remote working, or otherwise keeping the environment safe for everybody, keeping people further away, reducing the number of hearings at court, reducing the number of people in court buildings if they are going to keep the court buildings open, and keeping things hygienic. I know that the CEO of HMCTS on Friday sent out a missive saying, please let us know if there are problems with hygiene.
Oh, I thought he was joking, or she. I don't know, is it he or she? I thought they were joking when they said that, because where do you want us to start? I mean, why do we do it the other way around? Why do we let you know the ones that are all right? You can just deal with all the rest.
I started today. I sent her a message about the lack of soap in the court I was in. So.
Of course you did.
Yeah.
Cool. Whilst you were, how did you tweet that, Ben, from your phone if you couldn't wash your hands?
I had
I think we just outed Ben.
I had my alcohol gel with me.
Where did you find that? So I'm having some of that.
Yeah, exactly. It's in that cupboard behind him. Yeah. Yeah, and so Ben, that's an interesting idea, isn't it? Because a legal aid fund could be extended to, even just for this short period of time, to allow some money for people to access arbitrators. It's not the worst idea, is it?
No, it's not the worst idea. I think it's going to be very, very difficult to reintroduce legal aid and then turn the tap off at the end of the concerns about coronavirus.
We'll just keep it then.
I mean, or just keep it then, which is the real answer. Yeah. I mean, the real answer is they should never have abandoned it in the first place. It's a lovely idea, but it's never going to happen, is it? I mean, they're not going to. They're not going to reintroduce legal aid in the way it was. They've cut that cord and it's gone. So again, lovely idea, but we're dealing with a totally underfunded system here, and the solutions. I know you are concerned that you're banging the same drum about remote hearings. I'm concerned I'm banging the same drum about private FDRs. The answer is not within the court system, I'm afraid. That litigating within the court system is, for a number of reasons, a deeply frustrating experience for everybody involved. If you really want to resolve your disputes quickly and efficiently, and frankly as cheaply as possible, I'm a huge fan of taking the private route. Because
can I tell you my private FDR?
Yes, no, you said you were going to. Let's hear this now. Go on.
So I did an FDR last year where both parties attended from 2 separate locations in South America.
Yeah.
I attended from Dubai.
Yeah.
We had Alexander Chandler from One King's Bench Walk was our judge. We had counsel from 36 Family and from Helen's Chambers from Pump Court. So we had 4 different locations, 3 different continents, and the tech worked perfectly. There wasn't a single break in the flow of the streams that everybody had. One of the parties was doing it from their iPhone, and they seemed perfectly fine with it. The parties then had separately to the courtroom, online courtroom, their own online secure meeting rooms, which were just accessible by their legal representatives and themselves. At the start of the private FDR, our judge asked everybody to confirm that they were sitting on their own and in a private space, which everybody did. And then he warned them that if that changed, that he wanted to know straight away. And if they turned out that that was incorrect, then that might have consequences, in a wider sense, because they'd have completely frustrated the whole FDR, and maybe there'd be cost consequences for that. So he gave a little spiel about that, and everybody was very clear and all confirmed, and that was all fine. The meeting room itself was password protected, so that therefore satisfies the secure meeting room point. We could have recorded it. We didn't, but we could have done if we wanted to. And of course, when we cast our minds to hearings, there's no reason why we couldn't have provided that recording to the court staff or to Beverly Nunnery, a transcriber, to produce a transcript or just to have it on file if necessary. It was a private FDR, so obviously it lasted all day. Interestingly, I was able, because I was at my desk in Dubai, I was able to dip into other cases and dip back again into the private FDR because obviously I was in my office, and so I wasn't needed for all of it, which was helpful to the client because that meant that they didn't have to pay for the time that I wasn't literally working on the case. I was literally just billing what I was doing on their case, and it was helpful to my other clients because I was available to them to do bits and bobs as necessary. Counsel seemed perfectly fine with it. They were able to take instructions very clearly. We were able to, in our meeting room, share documents. And so what counsel did is every time an offer was made, they put it up on the share document and then they talk them through it. I don't know if you've ever done a private FDR with DDJ Chandler. He is brilliant, to be fair. And one of the things he does that is brilliant is produce a written indication. I mean, I don't know how he does it. It literally just produces it out of thin air, it seems. But this beautifully written, reasoned indication with a little asset schedule. So again, that went up on share screen, and we could all go through that line by line, and it worked absolutely beautifully. It was a really positive experience. And I was inspired. It did, yeah. They did settle. It settled on that day, and I was inspired by that. I thought, goodness me, I mean, if we can do that across continents. With, and the parties were all, like us sitting right now. It was very similar to this, actually. Just obviously a less esteemed company than you guys. And the clients who were fine with it. They followed everything. They were engaged. They were able, all of the cameras were on everyone's faces, apart from counsel, interestingly, because counsel took it in turns to have the camera. So the other barrister was just free to, make faces or whatever behind the camera, or hold up signs or whatever.
Were the two counsel in the same room together, or were the two counsel individually in there?
Yes.
They were together.
Yes. Yeah. So they were sitting opposite each other, and Alexander Chandler was at the end of the table.
So tribunal and counsel were in the same room. Everyone else was remote.
Yes.
Understood.
Yes.
Understood.
And it just worked really well. It worked brilliantly. And I look at that and think, my goodness, how many hearings do I do where that would just be perfectly fine? That would work without any question. Yeah. Everyone would be served. Every aspect of it is served. And I know one of the concerns about remote hearings is the ability to take instructions, or are you sure that the client really understands what's happening, because it's much harder. And Helen, I think you made a brilliant point earlier about the reality of it all. Does it just look, do you treat it like you're watching an episode of Friends where your mind just wanders off a little bit and you start thinking about the washing up or whatever? Do you take it as seriously as going to a court building? And as a barrister, when I was going to court, I was a great believer in that. I was a great believer in getting people into the court building, because then they take it seriously. And when you're in court, it's a serious place, and people very, very aware of what they're doing. But I don't know, I just think it's a cultural thing. And I think that, if we provide a viable platform that works, and instead of trying to pick every problem with it, and if something goes wrong, throwing our hands in the air and go, oh well, I knew it wasn't going to work, what a load of rubbish, shouldn't be doing that. I think people should really persevere with it, because I think if they do, I think it will really benefit clients in the end. And in the end, I guess that's our job, isn't it?
Yeah, I totally agree. I did a roundtable meeting not so long ago with a client in a foreign jurisdiction, and you expressed the concern that some people might have that when your client is not with you, present in the room, there's a distance, there's a lack of understanding, it's difficult to work through the offers with them. It couldn't have been further from the truth. We had offers up on screen, Microsoft Word. We shared it as a collaborative document. My client had the document open on her screen in the country she was living in. It was open on my screen in my conference room in London. I could make changes to the document. She could see the changes being made live. If she didn't agree with them, she could type her own comments on. We were actually able to work on the document together far better than actually if we'd just been in the room together. It was incredible. It's amazing what technology can allow one to do. And ultimately, I think the point you're making, Byron, and I agree with, is if the process is set up appropriately, if it's set up well from the beginning, you can have better results from remote working than you could ever do in a court-based FDR, with all the difficulties that come with being on a court list and being with 5, 6, 7 other cases all listed at 10 o'clock with no conference rooms, everyone crowded around, lever arch file on your knees. And that's no environment in which to settle a divorce or any other litigation.
I agree with you. Well, can I just talk to you from the perspective as a solicitor as well? I mean, I'm a bit of a unique case because we only do international work. Today, I've spoken to clients in Mauritius, in Kenya, and Dubai, although all of them are remotely for reasons beyond my control. And that's something that I'm used to doing all the time. And people who live internationally are also used to dealing with people remotely as a matter of course. But one of the things that I strongly believe, dealing with professionals in other industries as I do, and talking to them all the time about their way of work and their lives, we are so far behind in terms of how we work to other professions. There are some professions like PR or marketing who think of email as being really old school and really antiquated. They use WhatsApp groups or other speedier, more instant forms of communication.
Slack
and
or
here,
Yammer or whatever it might be.
Yeah, and the idea, when I think of the more tech savvy people that I have represented over the years, people who work in finance or advertising or PR or whatever it is, if I was to go to them and say, as an industry, we're really struggling with the concept of meeting each other remotely to do hearings, I think they'd genuinely find that laughable, because I think they've been doing it for years, literally years.
You're right, absolutely, 100% agree with you.
All right. Well, I'm going to stop banging the remote hearing drum because sure everyone's bored of me going on about it. But it's it's something I feel passionately about. Should we move to part 2?